Someone make it make sense.
I'll be a couple.
Hello, and welcome. This is not much to look at.
So in the courtroom.
Okay, there we go. That's a little bit better. So, okay, guys, for those of you guys who were following the Rose Petal Murder Trial, okay, came in and out like a whirlwind in like less than 2 weeks, you know, tried, convicted, and sentenced. That last day was especially crazy when it was like closing arguments and like verdict watch, and then the verdict came back really quickly, and then they went straight into sentencing with like a 10-minute break. It was absolutely insane. So Zachary Hughes has been convicted and sentenced to life without prison. So this was in February, of course, and you know, of course, there's been plenty of other cases lots going on in the world of law since then. So I'm happy to say that now I've been waiting to see when there was going to be follow-up to this, right? And of course, if anyone was going to get an interview with his attorneys, it was going to be Will Folks. So of FitsNews, of course, right? Huge resource. They were the ones who first started talking about this case when it first happened. And, you know, of course, they are really one of the South Carolina authorities to get the actual scoop, especially from the locals. So anyway, so we finally have an interview with Zachary Hughes's attorneys. And of course, there's going to be certain things they can't talk about, right? Obviously, attorney-client privilege, but we're going to get some insight here into how they developed their trial strategy and also what they thought of him as a person. And I've seen part of this. I didn't watch all of it because I wanted to be able to watch it with you guys and give my impressions as they arise. And I literally, as soon as I started seeing this, I went ahead and made the thumbnail and scheduled the live stream because I was like, yeah, we need to watch this. So, and oh, it's St. Patrick's Day, of course. Happy St. Patrick's Day as well. Happy to see you, Black Witter. See, I don't even, that's right, it's the 17th. I didn't even think about that. So happy St. Patrick's Day to everyone, especially those of you guys who are joining us from the Republic of Ireland. Okay, so without further ado, so we're going to take a look at this interview. It's not very long, but again, it's got some good information here. So let's go.
Room behind me last month, we covered one of the most controversial, complicated murder cases in South Carolina history, the Rose Petal murder. If you follow FitsNews.com, you're familiar with this case. We covered it gavel to gavel. It ended with guilty verdicts for Zach Hughes, the accused, now convicted killer in this, again, incredibly complicated case. The Rose Petal murder involves the killing of...
It's not an understatement, right? I will say things became less complicated as it went on, thanks to him taking the stand. But literally, this was a lot to sort through.
41-year-old Christina Parcell, a vet tech in Greer, South Carolina. Now, that's where the simplicity associated with this case ended. And entering the drama were a whole host of characters tied to the murder, but also attendant allegations, including allegations related to child sex abuse materials or child porn. Now, those allegations tied directly to the victim in this case, which in the minds of many made this a justifiable homicide. Now, as the defense developed over the course of months leading...
And I will say that Twiz, one of our favorite Squirrel Crew friends here, who's who's always here, except isn't here right now, which I'll get to. So he has been he's not been shy about being in that camp, which is that this was a justifiable homicide. And he lives in Pullman, Washington, so it's 3 hours earlier there. He has told me like that if I'm going to be going live, and it's like a time where he might be asleep, to call him because he's probably still asleep. And since he's not here, I would think he's probably still asleep. Anyway, I called him right before I went live just to be like, Twiz, because I knew he wasn't going to want to miss this. Anyway, he didn't wake up, but maybe he'll join us. But I just wanted to say that, and I'm sure he's not the only one, but he's just been very vocal about it, right? Sort of vigilante justice type of thing.
And up to the trial, no one knew exactly where Zach Hughes and his counsel were going to take this case. Would he take the stand? What sort of affirmative defense would he offer?
And I should just say, in case anyone didn't watch all of the coverage, I should just say, in terms of the victim in this case, right? She was involved in not just essaying her daughter and her daughter's friend, at least one, for like 5 years. Not just her, but also her and her fiance. Okay, the victim and her fiance both. But specifically, like the victim herself, there's videos that they have of just her and the daughter, and so they were involved with saying the daughter and the daughter's friend, and not just that, but creating and distributing CP materials of said acts. That is a thing. And also, again, this has been borne out based on we can't see it, obviously, so like we don't want to see it, but this is in all the criminal charges that being brought forth. There was also bestiality, and she worked as a vet tech. So this victim, we know, like bestiality, essaying, and CP materials created and disseminated, not just possessing, but worse, really, in my opinion, with her daughter and her daughter's friend, had been going on for like 5 years or something like that. And so yeah, I just wanted to recap that because, again, not everybody probably watched this trial, and it was very complicated. So welcome, James. Happy to see you again. Awesome. So you can see where, and of course, the defendant took the stand, and that was his defense. Like, his whole thing was like, it was to save the daughter, because what, the defense theory of the case and what he testified to, Zachary testified to, is that, people had tried, like the daughter's actual biological dad, who was in Italy, like there had been attempts made to get child services involved. Like they'd contacted child services, they'd contacted the different authorities, they'd tried to get people to step in. Nothing was happening, right? Nothing was happening because every time they looked, they couldn't find evidence of anything, which is true. They couldn't find evidence. Turns out it was going on. That's the thing. It was going on, but they couldn't find evidence of it. But now we know it was going on because what happened was, after the murder, right? Then they were able to do a more thorough search warrant of the fiance's phone, because he was obviously a really good suspect for it. He found the body. He was the fiance. It wasn't until a week after the murders, when they got the Celebrite and they took the phone, that then they uncovered confirmation that this had been going on. And that's what happened. So when they looked into it prior to the murder, they couldn't find any evidence. And then after the murder, then they started finding all of the evidence. It had been going on. So when the defendant took the stand, he was saying, like, the only way to save this child from this situation, right, was to basically take out the mom, essentially, right? It was their theory was it was a justifiable homicide, right? So hopefully that gets everybody kind of up to speed. And so we're going to hear again from his defense attorneys.
He simply argued that yes, he committed the killing, but that it was justified. This week, I sat down with his two lawyers, Mark Moyer and Andy Mormon, to
let us know if you want a custom command, since you don't have one yet.
Get their thoughts on the Rose Petal murder and the many challenges associated with defending Zach Hughes. Here is our conversation. All right, guys, I want to thank y'all for taking the time to sit down. Mark Moyer, Andy Mormon, the defense counsel for Zach Hughes in the Rose Petal murder trial. First question I got to ask you guys, did you ever think this case would blow up the way that it did? Yeah, it attracts so much attention from true crime aficionados all over the country. Was it surprising to see that level of attention?
I think anytime any case, gets as big as something like this, yeah, it is surprising. But, in retrospect, the people that we're dealing with here, if any case this would be it. I mean, Zach Hughes, just an amazing and fascinating and talented person. So if any case would get that way, it would be this one.
I agree. We thought that there'd be some media attention. Just speaking for myself, I didn't think it would be this widely followed. So it was a surprise.
Yeah. Well, let's start with Zach Hughes, your client. Tell us about the man. You spent a lot of time with him. What are your impressions of Zach?
Incredibly talented, as we just said. He just right off the bat, you could tell he was just an extraordinary person. And you got to hear a lot about him in the trial and his background, the character that he was. He I would just say, just an incredibly smart and talented person.
Had a ton of family support, friends showed up on his behalf.
Yeah.
Is
Any thoughts on the guy?
He was, or is just, he was a pleasure to be around. He seemed to be always concerned with other people. He would ask us,
Let's hear that part again. This is interesting.
he was, or is just, he was a pleasure to be around. He seemed to be always concerned with other people.
You can tell Will Folks is surprised by that.
He would ask us, without getting specifics, he'd ask us questions about our family, how our families were doing. He was not, a person in that circumstance can be self-absorbed because it's very stressful. But I found him to be utterly concerned with other people, which is a very unusual characteristic in a person, especially a person who's under that much stress. So just.
Now, what I will say is this, I'm going to just offer every side of this, right? Because essentially it's like either this was a justifiable homicide, like, and either he was justified. I guess either way. Okay. I guess even if you think it was justified or even if you don't, there's many people who could say that comes across as like a psychopath or a sociopath or something along those lines, right? His testimony on the stand, and just, I don't know, it's totally up for interpretation. It's completely subjective, right? I'm just going to offer this, that for those who kind of are thinking that, right? You can have somebody who's genuinely interested in other people, and that can be a genuine thing. But we know, right? There's plenty of examples of psychopaths or sociopaths, right? People who have been diagnosed with antisocial personality disorder, or maybe undiagnosed, but leaning in that direction, what have you, where that can be a thing that they do to try to learn about the other person and then, manipulate them. I mean, not that I'm saying Lori Vallow would be in that category. I think she's her own brand of whatever. But one thing that stuck out to me with the Keith Morrison, because we watched Nate Eaton interviewing Keith Morrison about what it was like to be around Lori Vallow. And one thing that was so surprising to me was that Keith Morrison said he genuinely liked her, that he enjoyed talking with her. He was charmed by her. He was genuine. He said it was the most frustrating interview he's ever done, but yet he found himself saying, I would do it again. I would do a second one. Right. Like he really the way he was smiling, it was almost like, it was crazy to see. You could see that that was the thing. Right. So kind of, different, but just as an example of like how people can have their way of, if they are manipulative, right? I'm just saying there's different ways that people can go about it. So I just wanted to say, I find it really, but you can tell that the way he's describing it, and the other attorney as well, you can tell that the way they interpreted it was genuine, right? And not manipulative. So let's just back it up again so we can hear this, because this is really interesting insight into what their impression was of him.
With other people. He would ask us, without getting specifics, he'd ask us questions about our family, how our families were doing. He was not, a person in that circumstance can be self-absorbed because it's very stressful. But I found him to be utterly concerned with other people, which is a very unusual characteristic in a person, especially a person who's under that much stress. So just, as Mark said, extremely talented, bright, and just had a general concern for other people as opposed to himself.
I'm going to go ahead and go out on a limb and guess he's probably the most unexpected murder suspect you guys have ever defended. Is he the most unexpected, convicted killer you've ever seen, just based on that background and his?
It's unusual to represent
someone.
someone.
I will just say, for anyone who didn't watch the whole thing or doesn't know, but is just here because they're like, yeah, we want to know what this is all about. Zachary Hughes was a classically trained pianist who went to Juilliard. Okay, incredibly talented, elite classical pianist, which is why for me, and even going into it, I was like, holy crap, like I've got to cover this, right? Because this is like my worlds are colliding here, right? I will say I never expected to see a classically trained pianist even as a defendant in a homicide, let alone convicted. So yeah, that's who he is.
Like Zach, who's charged with such serious crimes, absolutely. It's funny when you've done something this long as we have. It's hard for things to be unexpected, but But I would say that who Zach is, his background, it's very unusual to have someone like him charged with these types of crimes.
I'm also going to
That's,
go
and
out.
that's exactly why I'm trying to throw these little things. So yeah, so this happened. The trial was in February, and we covered it gal to gal. It was not a long trial. It is dubbed as like the most complicated, incredibly complex trial ever. And so, but it became had the defendant not taken the stand, we would have all finished this trial with just like more question marks than anybody could even fathom, right? Like after the state's case finished their case in chief, that's how I felt. That's how everybody watching it felt. We figured that's how the jury felt. But things became more clear as the defendant took the stand, but that was his choice. And had he not done that, it would have been different. Also, because the defendant took the stand, in the middle of his testimony, they made another arrest, which is the whole thing too. I mean, how often does that happen in trial, right?
A limb and guess that this was not the typical defense, that there were a lot of moving parts to this defense, a lot of things that were dependent on things that would happen during the trial, during pre-trial motions. But you guys were obviously dealt a very difficult hand very early. One of the first evidentiary hearings, DNA evidence was rolled out. There were camera footage. It was very clear pretty early that there was some connection between.
You don't have to apologize that you said you thought he was guilty. You don't have to apologize. Why would you be sorry for that? What I'm saying, again, because there's people who haven't heard of it. I'm saying like that there's people, well, and I said this in the beginning, like that there's people who definitely think it was justified. Twiz is being one of those people. Like I'm saying that because he's been very vocal about it. There could be other people, right? But he's been very vocal about that. And then there's other people, so okay, let's just recap. So in terms of guilty or not guilty, he admitted to the murder, right? So let's just recap that part. So technically he's guilty, right? He admitted to the murder on the stand. And in fact, in opening statements, his defense said he's going to tell you he did it. So technically that already means guilty, right? He pled not guilty, but he's saying he did the murder, right? So then the question becomes, like, that's why their defense theory was this justifiable homicide. Now, part of the challenge was they were not allowed to bring in, right, the evidence of the essay and the CP and all that stuff, which is what they're saying was his reasons, the reasons to justify it. Now, when he was on the stand, it was interesting. It was crazy because he would start blurting that out, and then everybody would be, chaos would erupt. And it's like, you can't say that. Da, da, da. So he did. And actually, there was a juror that spoke out afterwards and said that they were told, the judge told them, kept giving them curative instructions, disregard it, disregard it, disregard it. And usually those don't work, right? We always hear the toothpaste is out of the tube. Normally those instructions don't work. According to this juror, those instructions worked, and they actually disregarded it because this juror said, had they been presented with the evidence that this was true, it might have been a different verdict, which is exactly the thing, which is exactly this whole thing of the justifiable homicide. In other words, that could have been successful, but with all the motions in limine and all the pretrial litigation and hearings, they were not allowed to bring this in. And of course, as they're going to talk about, it's going to be their biggest issue on appeal, right? That they could not bring that in. And it's especially interesting that juror said that could have changed the outcome. So in other words, guilty as in, yeah, he did the crime, but this juror said, had they seen the evidence of the essay or whatever, now once the trial's over, now they know about it, right? It's like it might have been different,
Zach and this crime. Did you guys feel at that first moment when you saw
to Meg, you don't have to apologize for saying he's guilty because he says he did it, right? So I mean, that right there, and no one should feel bad for their perspective no matter what. I don't judge anybody for their perspective. I think that if anyone were to say they think Alex Murdaugh is factually innocent, I mean, we might need to have a little bit of a chat. But it doesn't mean that that I think anything about the person that would even say that, right? But I think that I would actually, I would say maybe we need to, but when you have all the information, right, no one should judge another person for how they interpret it, right? It's subjective.
Saw some of that initial evidence at that preliminary hearing. What are we up against?
So anytime you defend somebody, whether we were both former prosecutors and whether you're a prosecutor or a defense attorney, if the case is in a trial posture, part of the preparation is to be prepared for what may happen. And so you're constantly, you're trying to determine, first you review the discovery to make sure you understand what the evidence is very well. Then you're trying to determine the most effective ways to mount whatever defense may be applicable to the facts and the law. And so in coming up with that defense, you're constantly gaming out scenarios as to what may happen at trial so that the defense stays alive. And so at least the way, and I think Mark agrees, the way we think about it is we're never sort of enamored with how strong a particular case is. We're more focused on if we're in a trial posture, what's the defense? How do we effectively get that defense in front of the jury, and giving ourselves as many different opportunities as possible, depending on what happens at
Like a
trial.
chessboard.
It is. And it's, going back to this word unexpected, a trial is a very fluid thing. So no matter how much you prepare for trial, you can never be completely certain as to what's going to happen. That's why you want to prepare as much as possible to lessen the chances of the unexpected happening. But bottom line, going into this defense, as we would any other case, we're constantly trying to determine what is the defense, how do we effectively convey the defense, and how do we keep it alive, depending on how things unfold at trial.
So James is asking a question. So James, the defendant, well, he's not convicted. He had never met the victim. Had never met her. They were not in an affair. Literally, that's what's so interesting, right? So we learned at the trial, because the rose petals were a big question. What we learned at the trial was the rose petals was the way he got in the door, because he said he had a delivery, and he had a delivery of flowers or whatever, and then according to the defendant, the flowers got strewn all about because it was a chaotic, whatever, scene. I think that there's some people in the chat who thought maybe that wasn't the case, and that it was, there's some things that were still kind of unclear in terms of the, again, it was a short trial. Like in other trials, there might've been more brought out to try to prove something one way or the other. The state didn't even try to offer a theory about the rose petals. The state didn't offer a theory about a lot of it. It was really crazy. I mean, it was probably the worst prosecution I've seen, all the way from like opening statements, all the way through their case in chief. Again, it was like when their case in chief was done, I was like, this was what? And a lot of people, myself included, thought that if the defense had chosen to not even put on a case, that right there, they could have gotten a not guilty verdict, because the state, in pretty much everyone's opinion, the state did not meet that burden. Like it's really interesting, because the defense did put on a case, and the majority of that, if not all of it, was the defendant on the stand confessing, basically. So you're very welcome. So yeah, so that's how the roses got there, was because the defendants and it makes sense, because one of the questions I had was, how did he get in the house? And again, the state never offered any answer to that. They never, because we know that was a whole thing about these doors, right? We know that the front door was locked, and he was able to get in that door really quickly because we have it on video, or they had it on video. Couldn't see his face, but you could see the person on video. So, but the state didn't try to answer a lot of these questions. The state didn't even attempt to answer, but it made sense when he said, "Oh, that's how I got in the door. I said I have a delivery, roses or whatever," and then that's so that actually makes sense. So, they had never met, and this was something where the baby daddy, who was in Italy, was friends with Zachary Hughes. That's a whole other complicated story that is not easy to summarize. But what I will say is this. So to answer the question of how did Zachary Hughes even learn of this victim, Christina Parcell, he learned of her through John Mello, which is the baby daddy. Okay. Because the baby daddy and him became friends. And then John Mello, pretty quickly after they met, started telling him about all these concerns he had about CP and SA and all this. He didn't say CP. He said SA though. And he started telling Zachary about all these concerns, and it became a whole thing. Then John Mello's in Italy. And then I personally think John Mello was manipulating Zachary. We're going to hear more about that as well. John Mello is the one who was arrested during Zachary's testimony, okay, on the stand. It's insane. But basically, he was telling all this information about things he thought that were going on. And it seemed like kind of, regardless of whether you think he was manipulated or not, it's clear, it is not up for debate, right, that Zachary Hughes was compelled to take action based on what he was learning from John Mello. So though he had never met Christina Parcell, that is how he ended up doing what he did, because he was so sure that this child was in danger, and the other attempts to try to get her out of that situation weren't working. Basically, this is the really summary version, because again, there's a lot of layers to this. And that's what a lot of people thought, right? That the rose petals was to try to make it seem like there was a lover. There was also a bag of cocaine found. That was really never explained by anybody, the bag of cocaine. But between the bag of cocaine and the rose petals, I should also add, it also seems like Christina Parcell had worked as an escort. That's still kind of unclear. That was as to if that was all just John Mello's faking that thing. There's just a lot. But let me just say it this way. It's possible that she was an escort. We don't really know for sure. But regardless of whether she was or wasn't, Zachary Hughes believed because of John Mello that she was. And so that's another thought initially, that the rose petals was maybe because to try to make it seem like it was something with someone met her as an escort, you know what I mean? And then the drugs, maybe to throw it in and make it seem like there was a drug deal going on. And so that's what everybody kind of thought going into it. But his explanation made perfect sense, which is it was a way to get in the door. So.
And that was certainly in this case an evolving process. And I wanted to ask you guys, before we get into the trial and some of the things that happened during the trial that kind of maybe caused you to shift on the fly, how did the defense approach evolve leading up to the trial? Were there strategies that you considered then abandoned? Were there debate between the two of you over what tack you were going to take? How did your defense evolve leading up to the trial?
Yeah, I mean, it was just many discussions.
Mm-hmm.
I mean, I couldn't even.
And I will say also to Meg saying this is a hard one for sure. I actually think the essay is gross and disgusting. The person needs to be punished and held accountable. I just never think unaliving someone is okay unless it's self-defense. Yeah, so self-defense. I mean, and Meg, my personal perspective is I agree with you, because it's still illegal. And the problem that I see with like the vigilante justice is people can have that, can be sure that people can be wrong. And that's part of the thing that was troublesome here, right? Because the proof that this was real, the proof that there was actually CP and SA and all this, the proof that was real didn't come out until after the murder. So in an alternate reality, it's entirely possible that he could have murdered someone based on what John Mello was telling him. And John Mello could have been lying and he could have murdered an innocent person based on what someone else was telling him. And John Mello had a lot of motivation to want Christina Parcell dead because of the child custody disputes, right? So it was entirely possible that John Mello could have been saying all this to get him to kill her so that then he can have sole custody of their daughter. And in fact, all of those things could have been completely false. My perspective is that John Mello got lucky because he actually didn't know for sure. Remember, every time that the Child Protective Services and everything looked into it, they couldn't find any evidence to substantiate it. They tried. The guardian lied on everybody. They all tried to find evidence to substantiate it because they wanted to get, obviously, right? And they couldn't find any evidence to substantiate it because it was so well hidden. So given that being the case, nobody had proof. Like nobody had proof until after she was dead that this was actually happening. So because of that, you could imagine a situation where, again, in another case, for example, if somebody's like, I think this is going on, but they don't have proof, even if they have proof. But my point being, they can always be wrong, right? And that's why it shouldn't be up to one individual to become, as they say, the judge and jury, right? That's why it's not, because that person could also have a mental illness or whatever, right? They could be any number of things. And that's why we can't have it, right? The world would erupt into absolute chaos if people could take justice into their own hands just when they thought it was. Think about all the time when people feel entitled because they feel a certain way, right? It's just, it would be a bloodbath. That's how I feel about it. So I agree with you, Meg, that, and I will just say for me, even if it was self-defense, I wouldn't be able to hurt another person, but that's just me. But in terms of it being justifiable legally, self-defense is a legitimate posture to take for trial, as, to say not guilty because it was self-defense. So, and she agrees that, and I agree with you here. I agree with you as well here, Meg. I also agree. That's the other thing. The thing for me where I felt really sick, like I was going to throw up, was the sentencing. I don't think that was the proper sentence. I agree there. In other words, I think that the jury was, it makes sense how they got to their verdict, right? Again, he admitted to doing it, right? But the sentence for me, I don't agree with, because I don't think it would happen again. I don't think it would happen again. And, you know, has literally not any type of criminal record, you know, and given all the extenuating circumstances. So for me, you know, I would have liked to have seen a smaller sentence, you know, or maybe like an extended period of probation or whatever, you know, or even just like an ankle bracelet, right? Type of thing for an extended period of time. Yeah. So again, it was like John Mello, I think, got lucky that there was substantiating evidence because it didn't exist until after the homicide. And Twiz is here. Yay, I tried calling you because you said to call you and wake you up. Hi, Franks. And then James says, crazy that life absolutely has to have evil in order to something. I think you might have left a word out there. Can't have one out the other. But welcome to you guys who are just now joining us. So percentage is still life full of pudding. Yeah. I, in other words, again, legally speaking, right? Like we were just saying, I think that the guilty, you know, that makes sense. But again, at the sentence though, is where I do take issue, just like Meg said as well. So.
Hundreds of hours, meeting after meeting, both with the client and with the two of us. Just
Zach was involved in that process.
as any client would be,
Sure.
as any client would be. So
Suggesting approaches or?
I'd rather not get into specifics.
Sure, yeah, that's fine.
But the
He wants to know if it was Zachary's idea, but of course, attorney-client privilege.
when a lawyer is made aware of what the evidence the state's going to use is, and when the lawyer has an opportunity to understand what the facts are from the client's perspective, then it's the lawyer's job to fashion defenses that are viable and persuasive. And so, as you said earlier, this case is a very unusual case. The facts are extraordinary, and so that combination requires.
You know what's so funny, Frankie? This has happened before with somebody else. Who was it? This happened before with somebody else. It was so random and we couldn't figure it out. And then it started working again. So I have no idea. It's just Nightbot. I have no idea. This happened with, oh my God, who was it? Stevie B maybe? Anyway, this has happened before and then it fixes itself. So we'll try again in another minute.
Out of the box thinking. And so
Right.
we just a lot of long discussions and just a lot of very profound.
Sorry, I'm gonna back this up so we can hear the entire answer to this question about how they came, you know, their defense theory of the case. So
Suggesting approaches or?
I'd rather not get into specifics.
Sure, yeah, that's fine.
But when a lawyer is made aware of what the evidence the state's going to use is, and when the lawyer has an opportunity to understand what the facts are from the client's perspective, then it's the lawyer's job to fashion defenses that are viable and persuasive.
You're
And so, as you said earlier, this case is a very unusual case. The facts are extraordinary. And so that combination required sort of out of the box thinking. And so we just a lot of long discussions and just a lot of very profound discussions.
Your thoughts?
Yeah. Yeah, I'm not sure I have anything to add to what Andy just said. Yeah, it was yeah. No.
that in the background. What are you referring to? Windows? I'm not sure what you mean in the background. Oh my God. Oh my God. What is that? That's something outside the window? Weird. That's weird. I have no idea. Oh my God. Oh my God. Oh my God. Wow. I don't know. I don't know what that is.
Discussions.
Your thoughts?
Yeah. Yeah, I'm not sure I have anything to add to what Andy just said. Yeah, it was
Blaming Mello would have been the
yeah.
like the obvious route.
I mean, the other thing that was important is we've tried many cases between the two of us, and so one of the things we said repeatedly is that,
yes, it does.
this type of case with the type of client we had, we were grateful that we had had that much experience because to your point earlier, there were a lot of things that happened that we had to pivot on. There were a lot of things that happened that required us to not necessarily to change the overall strategy, but to adapt to the evolving circumstances in the trial. So the countless hours we put into preparing for trial and the meetings,
We're looking at here.
I think we both feel like that preparation paid off the best it possibly could, and we needed that going into the environment that was the trial.
Well, talking about one of those sort of wrinkles you guys were throwing, Mark, I remember you and I ran into each other outside the detention center, September 2023. You were kind enough to give me some of your time after one of the hearings there, but those charges, the conspiracy harassment charges against Zach Hughes that linked him to this wild card in the case, John Mello. Let me ask you guys about John Mello.
Oh boy.
I guess the first big question I was asked, did you ever think about calling him to the stand?
Well,
I'm so excited he asked this question because that was something we were all wondering too, right? Like, well, and of course, because they didn't, he was again arrested during the defendant's testimony.
in any case like this, you have to keep your options as wide as possible. So, going into our trial preparation, you always wonder, well, could it come down to this? That we would call him, or would he be called by the state? And so we certainly prepared in that, but the way our defense kind of evolved, the way the case kind of evolved, as you could see, it never really became necessary to have to do that. So yeah, at the end of the day, no, we just decided not to, and we don't think we needed to.
Mm-hmm. And
I don't have much to add. Anytime you go into a trial, you identify the universe of possible witnesses, and you're always doing sort of the cost benefit analysis. Is it better?
How many times do y'all hear me talk about cost benefit analysis? I was like, oh my God. I mean, I know that's a thing that people say, but like not always so much when it comes to assessing trial strategy or litigation strategy. So I was super excited to hear him say that, because sometimes I say like risk benefit analysis, and like, no, and then I correct him, like, it's cost benefit analysis, right? Because it's like a business term. But I thought it was funny that he said that, because I do say that a lot.
For our case to call this witness, or is it worse for our case to call this witness?
Y'all
and so Mr. Mello was run through that filter as every other potential witness would have been going into trial and during the trial.
Surprised the state didn't call him or try to call
him? No, not really. Just based on, as you said, what you know about him and kind of the wild card that is there, it wasn't really a big surprise.
A lot of folks have referred to him as the cousin Eddie of this trial relating to the Murdoch trial, and cousin Eddie.
Oh my God, sorry, let's do it again. You guys know how I love it whenever Murdoch comes up in any other case.
Him and kind of the wild card that is there, it wasn't really a big surprise.
A lot of folks have referred to him as the cousin Eddie of this trial relating to the Murdoch trial, and cousin Eddie being the witness that neither side ended up wanting to call. They feel like John Mello was sort of that type of witness, but given his integral involvement, his friendship with Zach Hughes, clearly they exchanged numerous messages, which we now know, based on your client's own testimony,
I know the commander's Frank.
We're tied to at least, if not a conspiracy, certainly collaboration and cooperation related to this crime. How does somebody like Mello get the kind of hold that he had over Zach Hughes? Because you look at someone like Zach Hughes, and again, I'm just somebody who doesn't know him as well as you do, obviously. Don't know Mello. But how does someone like that get a hold of someone so, as you mentioned, just insanely talented, gifted? You're talking about what a giving person he is. His rationale for committing this crime was, in essence, he's trying to help someone. How does somebody like that get mixed up with someone like John Mello?
I'm pausing real quick to say something that a lot of us, right, have thought that he was definitely manipulated the fuck out of. Remember, he could have tried to throw Mello under the bus, and he didn't. And also remember that Zach Hughes portrayed it, his testimony was he didn't try to say he was manipulated or whatever. He will, and I have thoughts on this, because remember, the defense is a justifiable homicide, right? As in, he was compelled And it was his own choice because he was compelled to do it. Remember, he said no amount of money would have made him do it. He was offended when John Mello offered him money, according to his testimony, to do it. He said, I didn't want to do it for money. I would only do it if I was sure it was happening. And you can see how that by offering being manipulated into it changes the landscape there, right? Because that's really more of like a not guilty because I was manipulated. And then you're almost kind of in a way going into like I wouldn't be an insanity defense, but like a mental health thing where like, you see how that could have been a defense strategy. It would have been a very different defense strategy. So when Zach testified, he didn't say he was manipulated, right? He really made it seem like it was a thing of like an honor thing, a duty that he had, ethics, almost like kind of like akin to like a martyr in a way, right? Like I wouldn't do it for money. I'm only going to do it because it's the right thing to do. And because of that, it had to be his own choice, right? It was his own choice. So I'm just setting the scene for those of you guys who didn't watch the trial. Okay.
I think I would dispute the premise of the question just a little bit as far as getting a hold of him.
Okay, hold on. I want to answer this question real quick before we hear this answer. So good question from Black Witter. Why couldn't the essay come into evidence? Because it was found by the court that it would have been too unfairly prejudicial to the victim. That's why. And for anyone who's like, well, hang on, the defendant's rights matter way more than the state's. Yep, they do. They certainly do. And a lot of people might question whether or not this was the right choice. The judge, however, he was a great judge. He followed the case law, and it could be that it's like a South Carolina, the South Carolina case law, right? When weighing it out, he made a very thorough record, whether we agree with it or not, right? That was the people who are attorneys and legal experts in South Carolina say it was technically the right call, even if it feels like the wrong call. However, it is going to be the biggest issue on appeal because remember, that juror that spoke out said, had they been able to see the proof of the essay, it could have changed their verdict.
In essence, he's trying to help someone. How does somebody like that get mixed up with someone like John Millen?
I think I would dispute the premise of the question just a little bit as far as getting a hold of him. Mm-hmm. As you heard, there was testimony in the trial about a friendship, but as Zach testified, what he did was not based on any kind of hold that John.
He said as he testified. And remember, this is crucial. They're only going to go off of what he testified to, 100%, right? And he says, as he testified, right? We heard it from him.
What he did was not based on any kind of hold that John Mello had on him. He did what he did because he believed it was the right thing to do. Mm-hmm. And it was not because of anything any type of manipulation or anything that John Mello may have tried to get him to do.
You don't think John Mello spun him up?
No, I don't. I mean, he got information from John Mello, as you heard in the trial. But Zach did what he did as he testified to because he believed it was the right thing to do, not because he was manipulated.
Yeah, do you agree with that?
Totally. And to Mark's point, I think the testimony showed that Zach's testimony showed that he was very deliberate in trying to understand what was happening. He was given documents. Mr. Mello, the evidence was that Mello provided Zach with information, but he didn't take, and even our pleading said this, Zach did not take the information that Mr. Mello provided at face value. And he wanted to understand what was happening. He wanted to be right. And ultimately he was right as far as the concern. Right.
But the thing is that proof nobody had until after the murder. That's what's so interesting because it doesn't actually make a whole lot of sense for him to say, the way that Zach testified, he didn't say I needed to see proof. He was very careful. He didn't say I needed to see proof. What he said was I wouldn't do it unless I was sure I was right. But then the thing that is missing is the part, and like what they end up saying is it's because he saw the girl on the FaceTime call and she looked different or something like that, right? But remember, that's what's so wild, that even though there is this proof, remember, the proof was not known at the time. That's the other thing that makes it so wild, that the proof did not come out until after the murder. But he was right. But You know, in other words, and what I mean, I guess, is like evidence, right? The evidence that it was actually happening, nobody had until after the murder.
Concerns he had for the
It's
child.
like catch-22.
I thought that was his most compelling moment on the stand when he made that declaration, and I was right. I thought that was his most
Right.
compelling moment. Let me ask you guys about this, about what he was right about, the elephant in that courtroom for the entire 2 weeks. And I want to
Not
start at the
legally.
end of the process and kind of work our way back. I'm sure you guys have.
So John Mello in his filings says he started making these allegations in 2017, but in the filings, that all came out again after the evidence came out, which is after the murder. So, you know, in other words, it's like hindsight is 2020, or like now that you have the evidence, you can say how far back it went. But like he was making the allegations at the time without any corroboration. But yeah, again, you can know without proof, but legally that doesn't help you, right? Because anybody can think anything is happening. It's just, that's why you have to have evidence.
Read some of the coverage since the trial about what jurors were thinking. I think you said you hadn't talked to any of them yourselves, but you've seen accounts in the media. The jurors were upset that they didn't get the full story. They were upset that they didn't know the why. Let me ask you guys about this. Were you surprised that
No, he didn't.
it didn't come in?
Was he did not have evidence. There was not evidence. It did not exist until after the murder. How would you say that they're different? Evidence is different than proof? What's the difference to you?
At any point, the child sex abuse material, child porn allegations against the victim, in this case, Christina Parcell. Mark, were you surprised it didn't come in?
Well, you have to, when you go into a trial like this, you have to be prepared for everything, for whether it comes in or doesn't. Obviously, as you heard in the trial, this was an important part of our case.
It was a gut feeling. It was a gut feeling. Because the thing is this, right? Remember, Mello didn't even know about the CP. So of the stuff so in other words, what Mello thought was going on and was making these allegations, they were of SA. They were not of CP, even though that was going on. He didn't even know about that. But the other thing you have to keep in mind is this. This is really Mello's MO, right? Remember when the Guardian ad litem, he made the exact same identical allegations about her. Identical. It was kind of creepy. I mean, it's more than kind of creepy. It was a lot creepy. He made the same exact allegations about her, down to the letter of like the stuff about being an escort. And like, it was like really clear at that point that, holy shit, is this just like what he does? And then there were other people. I can't remember where this came out in the testimony but who was it? Oh, it was from one of the FitsNews people when they said they interviewed him, and they said like that apparently everybody that knows Mello has had the same type of experience. This is like the thing that he does. And so in a lot of ways, it was either a gut feeling or he didn't actually know, and it wasn't a gut feeling. It was just him doing his MO and making these allegations to try to get child custody, and he got lucky. I think it's one or the other. He did not have anything to go on at all. And again, remember, he made those same claims against people completely unfounded, right?
The defense of others, defense of another, which is why
there's a lot of reasons.
Okay,
hold on, Twiz. There's a lot of reasons somebody can gain weight. There's a lot of reasons somebody can gain weight. Sudden weight gain doesn't mean the only reason for that is because you're being essayed. It's just not the case, right?
Zach acted as he did. So, we were trying to prepare for any eventuality that came about. So we were trying to prepare for whether it did or didn't. We felt it was important. We felt that it was an important part of our case.
Hold on, sorry. I'm not trying to. In the court filings that we covered, Mello himself says that the only thing he had to go on, the reasons he thought SA was happening, this is from his mouth. What he says is because of Christina's background as an escort and because he felt Brad Post was creepy. That's it. That's it. That's it. That's what he says in his lawsuit, right? Where you're going to put forward your strongest. If you're coming at people as a plaintiff, you're going to put forward the best case. Like, this is your chance. Usually people exaggerate to make their case better, right? And what he said was because of Christina's background as an escort and because he thought Brad Post was creepy. And that is it. So
the defense of others, defense of another, which is why Zach acted as he did. So, we were trying to prepare for any eventuality that came about. So we were trying to prepare for whether it did or didn't. We felt it was important. We felt that it was an important part of our case, and that it should be something for the jury to consider. You just never know, I think, going into trial, what evidence is going to come in or not. So
Do you feel there were moments, and either one of you please answer this, did you feel there were moments during the trial where the door was opened for that evidence to come in?
Opening the door.
That was one of the evolutions that was most surprising. When we were putting together the defense, and we filed the pleading on Tuesday morning, that was very comprehensive as to what the defense was going to be, what the facts were, we were going to prove, and how the law applied. Going into the trial, we were prepared to make that argument. I'll just speak for myself. I did not believe that there would be additional bases for admissibility that would come up during the trial. And so I was surprised that during the trial, there were at least, I would argue, 2 separate times where the door was open, where we didn't expect that to happen, where this evidence arguably became even more admissible.
And you guys moved very quickly when that happened as well.
We did.
And you were surprised Judge Fan kept it out at that point?
We argued very aggressively during the trial that it was admissible. We believe to this day that it was admissible, but Judge Fan disagreed. The court disagreed, and that happens with frequency. So we believed it was admissible, and the court disagreed.
I talked to an attorney.
And I will just say real quick too. So for anyone who missed it, so I have a playlist for this and for everything else I'm covering, but we had a live stream where we just went over the lawsuits. So for anyone who missed that and wants to take a look, also I will add that in the Discord there is a thread for this case, and DSN, shout out to DSN for this, has put a link there for somewhere. I think it's a Google Drive thing or whatever, but somebody on the internet has put together like all of the court filings with Zachary, but also the, Zachary Hughes adjacent, right? AKA Mello and Bradley Post and Christina Parcell. And they're all there and available, and they're organized. So some angel on the internet did that and took the time. Read it. Thank you, DSN. But DSN put that in the Discord. So I'll put a link in the Discord for anyone who hasn't joined. And you can find those as well in that thread. So because while we covered some of them, I don't think we got through all of them. But we did cover the ones that seemed to be the most crucial in terms of the claims about, again, we covered the entire John Mello, lawsuit and whatnot. And I think there's like 2 filings there, but anyway, the one, because when I was going through and looking at the different documents, I wanted to start with the ones that seemed to give us the most insight as to what these claims were. And I think the time when we covered them, it was before Zachary had taken the stand, because we had a weekend, right? And over that weekend, I think was when we covered those filings. And then like on Monday, the defense was supposed to start their case in chief, and then it was like delayed, and then he took the stand. So anyway, but there is you can also check out the playlist. So
Earlier this week about this case and about the forthcoming appeals process, they used the term baked in the cake. And I thought it was an interesting turn of a phrase. And I said, what do you mean by that? I said, well, he's going to get a new trial based on that evidence not coming in. As you guys, and first of all,
I should add real quick. The lead prosecutor did a press conference right after the trial, or after the sentencing and everything, that I didn't see until after the fact. I don't know that it wasn't like broadcasted. I think only one local news outlet had it, but I didn't see it until so in other words, we stayed live waiting for some more coverage, and then nothing came about. And so we switched over to watching John Mello being at his bond or whatever. But there is an interview with the prosecutor right after the conclusion of everything, which we haven't watched. So if you guys want, we can watch that after this. Just let me know if you want to see it.
Let me ask you this. Are you guys going to handle the appeal?
So we have filed the notices of appeal.
The notice, correct?
Yeah, we have filed that to preserve Zach's right to appeal.
Yeah.
We're still working through that process as to what our involvement is going to be.
Yes.
So we don't know yet.
And a lot of times it's
And
handled by
that's the thing.
different
Like
attorneys.
exactly what I said, right? Totally. It could have been intuition. It's either intuition or he got lucky, right? It's one or the other, because there was not evidence. But I agree with you. But yes, again, like I keep saying, right, with the law, that doesn't mean anything, but it does mean something in terms of people's interactions in daily life, and intuition is very important. But yeah.
And certainly everyone understands that, but thinking about that appeals process and that comment, how significant do you think that decision will
I think
be
I might have
as
sent
a Zach Hughes appeal of this conviction starts to take shape? Will be the central thrust of that?
I put it in the
or-
Discord. We didn't watch it.
It'll be an important thrust. It'll be important. It's hard to say in the absence of actually putting together the brief as to what's going to be the most important, but I think it's undoubtedly a very important part of the basis for the appeal.
Mhm. Mark, what are your thoughts on the appeal process?
Yeah, as Andy just said, that is going to be one of the main features of the appeal. We believe there are several issues, and so we're just going into it optimistic that we will succeed.
You guys preserved a lot for the record in this case. There was a ton of proffered testimony, evidence. Is that, again, as you were working through that part of the case, conceptualizing that, a lot of that was obviously stuff you thought the jury would hear, based on not only the door opening a few times during the trial, but that'll obviously be key to the appeals process.
Yeah, absolutely. As you know, the appellate courts can't go outside of the record.
Right.
And so during this trial, we just had to be very, very aware of and very diligent about trying to make sure the record was as complete as possible. So we had a number of witnesses, as you saw, that we were unable to, get in front of the jury. And so whenever we had the chance and the opportunity arose, that we just had to take that opportunity to, as you said, proffer that testimony and to summarize to the court as best we could what that witness would have testified about. So that was a very important part of the case.
And you guys both done federal work as well. Do you see the potential for, again, if the state appeals route dries up, if you can't keep that alive, do you see a potential habeas here?
I think it's too early to tell.
Mhm.
Honestly, I think there might be a better understanding once the issues firm up on appeal and the briefs are constructed. I think it's probably too early to tell right now.
Let me ask you guys about your client taking the stand. One of the things we've heard from folks who were close to the deliberations, they felt he was off-putting. They felt he was a bit too antiseptic about this crime, which again, if you look at it, he's admitted it, and it is an incredibly graphic crime. The testimony of the forensic examiner, I was in court that day, it was chilling to hear her very dispassionately go through the list of those individual wounds. But let me ask you this, as it relates to Zach's decision, was that something he wanted to do? Was it something you told him he should do? Certainly he received plenty of guidance from the court before he made that decision. But looking back on that decision,
Decision to take the stand.
should he have taken the stand? Anything he could have done differently, better to sway that jury away from the verdict it eventually landed on? Mark?
Well, Will, as you heard my opening statement, I stated that Zach has been waiting a long time, 3 years, to get in front of that jury and to tell what happened.
Mm.
Obviously, we can't go into the back and forth that we had with Zach, attorney-client privilege, but Zach wanted to tell the truth.
Mm.
And as lawyers, you're your client's agent.
Mm.
And so when it came down to it, at the end of the day, he wanted to get in front of that jury and tell the truth, tell what exactly happened and why it happened.
He wasn't able to, though, in a lot of circumstances. In fact, I think one of the things he said that was also very compelling was, Your Honor, I've sworn an oath to tell the truth. You're not letting me do that.
He said that. One of the components of this I think is overlooked. I do think it's very important is that On Tuesday, when we began our case, the trial court indicated that we would not be allowed to assert the defense of others' defense. And that we were very aggressive in the way we litigated that. But up until Thursday morning, the last day of trial, when Zach had completed his direct examination, there was still an element of the law that would have allowed the jury, we believe, to account for why Zach did it. And specifically, one of the things we argued was that the definition of malice, there are many definitions, but one of the definitions is the intentional doing of a wrongful act without just cause or excuse. And so if you notice in Mark's opening statement, just cause or excuse was what he said, which was still viable under the concept of malice, even though we had lost the defense of others concept. So even with hours, just a few hours before closing arguments, that was language we believed would remain in the jury instruction. We believe that that was black letter law. And so, so I think that's very important. I think one perception is that, well, the trial court ruled that we weren't going to get into the defense of others. So you sort of, why continue this concept of just cause or trying to explain? And again, one thing that's overlooked is up until about 2 hours, the last day of trial, 2 hours before the closing arguments, the jury could have considered that idea in the concept or in the context of malice. And so up until almost the very end, and the trial court disagreed.
They did a really good job of making
amended
an
the
argument
definition of malice to
about
remove
malice.
that language over our objection. He removed just cause or excuse. But up until the very end, it was evolving.
What was the motive for that decision to leave that language out?
And I think
I'd have to ask the court, but
well, I think the trial court put it on the record. And again, I would defer to the trial court's understanding, but my understanding was that the trial court believed that if we didn't get a defense of others instruction, then we couldn't get a just cause or excuse instruction. And our response to that was, they're different. The concept is different in different contexts. So for the defense of others, that's a defense.
yeah.
Whereas in the context of malice, frame of mind, that undermines the state's ability to prove an essential element. And so
one's offense from your end, one's defense. Right. Okay.
But again, the trial court disagreed. And so going into closing arguments, there was very little left available from a legal standpoint for us to explain to the jury that they had that they could account for his frame of mind.
Now let's give Prosecutor Walt Wilkins some credit. Seasoned prosecutor. He had an opportunity on cross-examination of Zach Hughes to really dive into some things. He made a calculated decision to ask one question. And a lot of folks have looked at that and said, well, what was he thinking? But that also limited you guys in what you could get into coming back to your witness. Were you surprised he did that? And did that kind of handcuff you guys a little bit at the last minute?
Well, I guess you'd have to ask the solicitor himself about his strategy, but it was probably a very smart strategic decision. Quite truthfully, Zach is, as we've been saying, is an extremely intelligent person, and we believe an extremely compelling person. So from a strategic standpoint, it eliminated the possibility of Zach being able to answer questions and to fill in some gaps to the jury. So, again, it probably was a pretty wise decision at the end of the day.
Now, Zach did get a few references in, obviously earned a contempt citation as a result, but, and I want to ask you guys this about this, because one of the other things we heard from the jury deliberations and sources familiar with those, a few times, and one time in particular, a door was left open between the jury room and the courtroom. And some of the conversation that was taking place about these very matters that they were told, and in this case, not told about, some of that was overheard. Is that the kind of thing that could potentially compromise this verdict?
To be determined. That particular issue, I think there's potentially an argument that that would cut in favor of Zach. But in just reading your coverage, again, we haven't communicated with any jurors, but in reading your coverage, it appears that the jury took the court's instructions very seriously. And so, assuming that be the case, and we have reason to believe it is, any communication they may have heard in the court that was inconsistent with the judge's instructions, I think they
This is
probably
what I
would
was saying
follow the
earlier.
judge's
They
instructions. So,
followed it. They did.
bottom line, I don't think we know. But it does appear again that they followed the court's instructions pretty literally.
There was a moment during deliberations, a note came back, one of several, but this one, when I saw it and heard it, felt like you guys had a real chance. When the jury asked the judge to, again, reissue to them that definition of malice. When you guys got that note, saw that note, what went through your minds? Mark, what did you think when you heard that?
Well, as we've been talking about here, and as you know, malice was the linchpin of this case. So when the question came back about malice, well, yeah, absolutely. We were like, all right, the jury is focusing on what they should be focusing on. So,
You're
yeah,
encouraged.
yeah, I would say so. Obviously, you never know in which direction they're taking that thought, that argument amongst themselves. But yeah, it was encouraging to know the jury was following and focusing on what was the essence of this case. And as we've been discussing, unfortunately, we were not able to develop that theory as much as we were hoping to do so throughout the trial. So I think that maybe, who knows, but that could be why the case ended up not going to the way we wanted it to go.
Andy, what were your thoughts when you saw that note come back?
I mean, it was a good development. We talked about at council table,
notes?
having tried as many cases, you just don't know what a jury's going
Worry
to do.
about the jury questions. When those came back, I was sure they were going not guilty. The jury questions totally pointed that way to me anyway.
So it's hard to extrapolate at that time what that really means. But it was a good development, and my closing argument was structured almost exclusively on that concept.
Yeah, the defense closing argument was excellent.
And so it was a good development.
Obviously, this case, the appeal, you guys have made it clear this is going to be, the notice has been filed. There's some significantly fruitful grounds
We'll cover
that
the
could be
appeal.
pursued here on appeal, but there are also other criminal cases tied to the Rose Petal murder. We've got the charges against Brad Post, the fiance of the victim, Christina Parcell, and numerous charges against him related to the CSAM child porn found on the site. Those are being, we think, prosecuted by the Attorney General. It's been a little while. They kept that on ice, perhaps not impact this trial. Is that the thinking?
You'd have to ask them.
Yeah.
Well, we've asked the AG. They've been very quiet about this case.
Yeah. It's and there's nothing wrong with this, nothing unethical about this at all. And like I said, we were prosecutors. Oftentimes prosecutors will go into cases and trials thinking about how they can maximize credibility of witnesses they intend to call. And when you have a cooperator who's charged with crimes, oftentimes it's more advantageous for that person to testify in an environment where there's been no promises made as to how his or her cases will be resolved, as opposed to quickly resolving the case and then having to deal with what the negotiation was. So nothing wrong with that. That happens all the time. And again, I'm not even sure that was the reason. You'd have to ask the AG's office.
So we've got that trial forthcoming at some point, we believe, or a plea. Then there's also the charges against John Mello. He was already charged heading into
If I were Brad Post, I would plea.
the trial with harassment and conspiracy, and he is also now facing
You do not want to get in front of a jury with that type of evidence if you're in Brad Post.
charges directly related to Christina Parcell's murder. So there will be a prosecution there. I sense that one will go to trial based on what we know of John Mello. You guys can track those cases closely as it relates to potential appeal and maybe having to retry this case if the appeal goes your way? You gonna follow those cases closely?
Yeah.
What are you looking for
absolutely.
as those cases unfold?
Great question. It's just we'd only be speculating to know what, or it'd just be pure speculation. But yeah, we just want to see what, who testifies, what do they testify about? What is Mello's defense going to be? How's that impact us? Same with Brad Post. What else are we going to learn about what was going on? And who knows? Maybe nothing, but trials take odd turns and twists. So we
As
could
we
learn a
saw.
lot more. Yeah.
Yeah.
And
So I agree with Mark. We're going to follow it. There's one thing we've learned about this case is things can change dramatically from one day to the next. So with Mello being arrested so recently on the new charges, I would imagine that would, as a practical matter, push back the timetable on everything. So it may be a while before we really understand how Mello's case is going to be resolved.
last question for you guys. This thing circles back around. If an appellate court finds that the probative value of the CSAM child porn should have outweighed the prejudice to your client, if they determine that he does indeed deserve a new trial, you guys back in it? And if you are, is there anything you learned from this first trial that you would change your tactics or strategy moving forward in a potential retrial?
Well, I guess to be determined a little bit about whether we'll be involved. I'll speak for myself. I hope so. Obviously, I'm extremely invested in this case. I was a prosecutor for 29 years. This case came to me about a week after I retired from the prosecutor's office and opened my practice. So this case has been my practice. Okay. I'm just hugely invested in it, just from a personal standpoint. So yes, I hope so, and we'll see. What have I learned? That's a great question too. I mean, I think I still need some more time to reflect on everything. So I'm not sure how to answer that question.
Yeah. So I agree with Mark. We care about Zach. I care about Zach. I hope that I'm able to continue to work on the case. Right now, thinking about round two and a trial is so far away. Zach has been convicted. He's been sentenced. And so that's a serious development, and we don't take anything for granted. So our concern right now with Zach is making sure that, again, we filed the notices of appeal, making sure that the appeal is done with excellence and done well, whether it's going to be us or someone else, and then go from there. As far as what I've learned, to Mark's point, it's a little early. One of the things that I think lawyers have to do when they represent clients is remain objective and be able to the best they can, put their emotions on one side and their thinking on the other. And
Don't know how y'all do it.
well, this is one of the cases. I think both of us typically do that pretty well. This is one of the cases that's been very hard to do because of the amount of time we spent with Zach, our ability to get to know Zach and his family. So if I could say sort of I've learned anything, it's that lawyers aren't robots, and sometimes it's hard to keep that to keep those dimensions separate. That's not bad. Because to your point, in a case like this, if you didn't have some emotions, if you didn't have some affection for the client, if you didn't respect the family, you wouldn't be human.
Guys, I really appreciate it. Before we go, anything you want to tell folks about Zach, about how he's doing in the aftermath of all this, about what his perspective on these matters as all these cases and the appeal and the other criminal prosecutions move forward? Have you talked to him? Where's his head on all of this?
So I think he's strong to begin with. He's strong. I think he I don't think I think he believes what he did was right. I don't think that's changed in the least bit. I believe that his concern still primarily is for others and not himself, even now.
Yeah, he's an extremely, as Andy said, he's strong. He's extremely disciplined person in mind and body. And so,
I mean, yeah,
no, we do not see
for sure
a change in him. He, again, as Andy said, he believed what he did was right. And he's unwavering in that. And he is prepared to face the future, however it unfolds.
I think this conversation has shown that could unfold a lot of different ways over the coming months and years. Guys, I can't thank y'all enough for taking the time to sit down. Really appreciate it. And certainly whatever folks think of this case and their views on the protagonist in this drama, I think everyone agrees you guys did a remarkable and commendable job advocating on behalf of your clients. So we appreciate you sharing that with our audience.
Thank
Very
you, Will.
much.
Appreciate it.
Thanks, guys.
Okay. I'm going to try one last time and see if Nightbot has decided to work for Franks' command. Nightbot, so silly. If not, I'm sure it'll work by the time we have another live stream. So Twist says, I love you, Zach. So there you go, guys. So again, when that appeal comes out, we will cover the appeal as the plan for the rest of the day. So of course, I'm keeping an eye on if any other documents come out for Karen Reed or for BK, because, you know, we're in the middle of the bazillions of motions in limine, and well, for BK's case, it's the responses and whatnot. So if something comes out for one of those cases, I would expect either or both of them will. Then we will figure out what, you know, we will cover that, obviously. If nothing else new comes out, then tonight the plan will be we'll probably pick up where we left off with Murdoch, or we might do Casey Anthony, because we need to continue on with our next episode of Casey Anthony as well. I'll sort of play it by ear again, just depending on what else comes out for those other cases. So we'll definitely have something. Well, remember, in the middle of the night for some is not in the middle of the night for other people. So, you know, but it's not working now for whatever reason. So, so who knows? Maybe Nightbot just is not a morning person when it comes to certain commands. So yeah. So, and for anyone who missed it, we did have our first members only live stream the other night. And we also had the video with following up on the real world true crime edition, and with the winners of the season 1 cast. The Scroll Crew has spoken, and those are the contestants. So if you didn't see that, definitely check that out too. The video is pretty funny. I remember Miss Q saying she was betting $150 on a 5-hole, because the question is like, who, if anyone, will survive? And she says 150 on 5-hole. Amazing. We don't know who won, but we have the cast of the final 12 is there. So check out the video for the final 12, and feel free to weigh in, you guys, in the comments on who you think who, if anyone, will survive out of the 12 that are going to be, you know, in our hypothetical season 1. We all won. Oh, you're saying who won for trivia? Oh, I believe Kit Smits, but yes, we all won. Technically speaking, points wise, I believe it was Kit Smits, but you know, not everybody was able to be there for the whole thing. And yeah, who won trivia? Yeah, I think it was Kit Smits. Yeah, and what we're gonna do for the next trivia, guys, for anyone who missed it, what we're gonna do is we're going to do different categories of trivia, like, you know, like there would normally be a trivia. But what we're going to do for anyone who wants is we're going to do categories where everyone feels like they would do the best, right? Because some people are like, if this was such and such thing, like I would win. And then like people start naming like their best categories. So for anyone who wants to do it, what we're going to do is what you can put in the Discord in the members only thread. If you want to weigh in, put your number 1 category. You get to pick one of what you want your category to be for the thing that you think you would do the best at for trivia. And what we're going to do for the next one is I will pick an even number of questions for each category. So that way everybody has an even equal playing field for how well they should do. And then if people have knowledge in other people's categories, then they will have an advantage, but it'll be really fun. For example, Cat Randall wanted trees because he is a tree expert, and that's where he works as he's an arborist, right? So there will be questions pertaining to trees, as an example, for Kit Smith's classical music, right? As an example. So that would be, who was the most hilarious? Everybody was hilarious. Everybody was freaking hilarious. Y'all were awesome. It was really funny. But yeah, for that first one, so what we did was we did legal trivia. And everybody learned, I think, quite a bit, or learned some, there were definitely questions on there that people were like, yeah, I didn't know that. And it was funny. It was fun. We learned. So it was a great success. Apart from the fact that a lot of people didn't get notifications. And I've been hearing that from other places as well. Like apparently YouTube's just having a moment where notifications aren't going through. So make sure you have all notifications turned on, and the Discord notifications so far out of all the years, like seems like Discord notifications are always reliable. So make sure you check the Discord. Any videos or live streams or what have you will be in the upcoming scroll videos thing, but it should give you an announcement as long as you have your notifications on for Discord. And even if you don't, you can just periodically go and check that, and it should have the upcoming videos. It should, usually I post when they're upcoming, but even if not, it does an automatic notification when we go live, which it did today. I got the notification, Chelsea Whitaker is live, right? It all sends that notification as soon as I go live in Discord. So you can always check there as well. But that'll be it for this one, guys. So we'll see you again. I don't know yet what we'll be doing tonight because I'm just playing it by ear based on what comes out for those cases. And if nothing else, like I said, we'll probably do Murdoch or Casey Anthony, probably Murdoch. But yeah, other than that, y'all are awesome. Love you guys. Scroll Crew's the best. And I will see you guys next time.